There is currently a heavy presence of armed operatives of the Department of State Services at the Supreme Court premise ahead of the highly anticipated judgment in a case involving the federal government and Nnamdi Kanu, the leader of the indigenous people of Biafra. VOP News gathered that the crucial judgment is scheduled to be delivered by the Apex Court this morning. However, in a bid to ensure tight security, the DSS operatives stormed the premises of the court this morning very early, blocking the road leading to the court and the Villa Gate, preventing litigants and sympathizers of the self-proclaimed IPOB leader from gaining access. Now, according to an online newspaper, the Daily Post, even journalists accredited by the Supreme Court and also possessing official tags were turned away from entering the court premises. Only after the intervention of high-ranking officials of the court were the operatives reluctantly persuaded to allow the journalists to enter. However, before gaining entry, the journalists had to be thoroughly frisked by security personnel stationed at the main entrance, which an unmarked security vehicle had obstructed. As of the time of filing this report, Justice Kudirat Kireke Ekun, the lead panel, is being awaited to make the decision of the court known. You do recall that on October 5, the Supreme Court slated today to deliver its judgment on the appeal that is seeking to compel the federal government to release the embattled leader of IPOB from detention. Well, eventually, the Supreme Court has reversed the decision of the appeal court discharging and the acquittal of the leader of the proscribed indigenous people of Biafra, Nnamdi Kanu, on the case of treason against him. VOP News gathered that the Apex Court held that although he was illegally brought back to Nigeria from Kenya when he jumped bail, that development could not have divested the trial court of the jurisdiction to continue his trial. The court, however, in a unanimous decision by a 5-member panel of justices, acknowledged that the federal government acted irresponsibly when it forcefully brought Kanu back to the country from Kenya against all known laws. It, however, held that it was not enough to divest the trial court of its jurisdiction to continue with the case. According to the Supreme Court, there is no legislation in the country that stripped the trial court of the jurisdiction to go ahead with Kanu's case, despite the illegal action that the federal government took against him. In the judgment that was prepared by Justice Garba Mohammed but read by Justice Emmanuel Agim, the Apex Court held that the remedy open for Kanu was for him to institute a civil action against the government. The court, however, stated that the federal government must be conscious of its image, both locally and internationally, even as it knocked the trial court for revoking Kanu's bail after he escaped to save his life following the invasion of his home by security agents. To talk about the recent declaration made by the Supreme Court today and to help us contextualize and put in perspective what the Supreme Court ruled today concerning Nnamdi Kanu regaining his freedom, I have via the telephone a legal practitioner, also a social affairs commentator and a political enthusiast, and that is Barrister Tunji Abdulhamid. Barrister Tunji Abdulhamid, good afternoon and welcome to VOP World News at 12.
Good afternoon, Esther. Thank you for having me.
Thank you so much. Barrister Tunji Abdulhamid, a lot of Nigerians, specifically Southeasterners, those who are in support of Nnamdi Kanu, they were quite, would I say, disappointed today with the ruling of the Apex Court. They did not give Nnamdi Kanu the desired release that a lot of, political stalwarts had mediated on his behalf. You'd recall that even before now, the governor of Enugu State, Peter Mba, also the governor of Anambra State, Charles Chukwuma Soludo, Ohaneze Imbibo, and a couple of other supposed governors who have, in one way or the other, tried to show that sense of leniency, have pleaded on President Bola Ahmed Tinubu to, in a way, to resolve the insecurity ongoing in the Southeast, to possibly use his position whereby the Attorney General of the Federation will drop the case against Nnamdi Kanu and see possibly that supposed peace that is being expected in the Southeast. But the Supreme Court disappointed today, and they rather gave Nnamdi Kanu an advice. They asked him that rather he should institute a civil case against the federal government, but that they would not divest. I need you to help me explain what that means.
I argue about, I think some of the things you said, but I know you are talking about Nnamdi Kanu's judgment.
You said you did not hear what I said.
Supreme Court.
Okay, so apparently the Supreme Court reversed the decision of the Court of Appeal, discharging the acquittal of Nnamdi Kanu, the proscribed indigenous people of Biafra leader. And according to them, it was led by a 5-member panel of justices. They acknowledged, this 5-member panel of justices acknowledged that the federal government acted irresponsibly when it forcefully brought Kanu back to the country. But they said it was not enough to divest the trial court of its jurisdiction to continue with the case. So according to the Supreme Court, they rather gave Nnamdi Kanu and his counsel an advice. The advice was for Nnamdi Kanu to institute a civil action against the government. And the court stated that the federal government must be conscious of its image, both locally and internationally. So the question I'm asking is, what does this mean? Because they reversed the judgment of the appeal court that asked that Nnamdi Kanu be released. So what does this mean?
I was forcing myself to hear you. I've not seen the judgment of the Supreme Court.
Thank you for watching. If you're new to this channel, consider subscribing so you won't miss out any of our latest video.